Now to the Supreme Court, where Martha Koome presided over her first case as Chief Justice earlier on today. So the court clarified that the now famous Muruatetu court case did not outlaw the death penalty in the country. Instead, the CJ said that the 2017 decision only sought to give judges the discretion to decide whether and when to hand the death penalty. But as Elfas Lagat now reports, the decision has now given a lifeline to death row convicts in various prisons in the country.
The inaugural session for the Chief Justice, Martha Koome, in her new role delved into a case that has become famous in the country, the so-called Muruatetu ruling of 2017, which has so preoccupied the judiciary that it featured even in the recently concluded Supreme Court vetting.
The mandatory nature of the death sentence, as provided for under Section 204 of the Penal Code, is hereby declared unconstitutional. For the avoidance of doubt, this order does not, and I emphasize, does not disturb the validity of the death sentence as contemplated under Article 26(3) of the Constitution.
The decision effectively giving judges a free hand in deciding whether or not to invoke the death penalty in murder cases. The original case involved two men, Francis Muruatetu and Wilson Dhirimbu, who were both handed a mandatory death sentence by Justice Mbagoli Musaga for killing one Lawrence Githinji Magondu over a piece of land in Kitengela. But the two moved to the Supreme Court to challenge the constitutionality of the mandatory death sentence, moving the court to find the Section 204 of the Penal Code as inconsistent with the Constitution. The ruling has caused confusion in the judiciary, with some courts extending it to cover crimes other than murder, such as robbery with violence and sexual offences. The CEJ now directing that murder convicts are free to apply for new sentences in light of the Muruatetu case.
This matter is hereby remitted to the High Court for the hearing on sentence only on a priority basis and in conformity with this judgment.
Koome, in her inaugural remarks, said she is committed to ensure backlog of cases are cleared and ensure justice for all Kenyans.
For us in the Supreme Court and other courts, the development of a jurisprudence of social justice, or put differently, a social justice jurisprudence, will be our guiding North Star in the next decade.
The Supreme Court, which is now fully constituted, is set to hear 19 appeal cases and 2 references between this July and October. Elfas Lagat, Citizen TV, Nairobi.